Basis for our following discussions and for our panel. Now I'll have the honor to present the first panel leader, Alexander Winkel, who comes from Vienna, Austria, and he works with international relations, and he will present his team, and they will look through 3 cases during the next hour or so. Please, the floor is yours.
Herzlich willkommen nach dem Mittagessen. Ich hoffe, das Mittagessen war nicht zu üppig, dass Sie in einen tiefen Schlaf verfallen.
Kindly welcome back from your lunch. And I hope you didn't eat too well and you will not fall asleep during the next hour. We will look through 3 cases. In the panel in front of the room, there are representatives from 3 countries, Austria, Latvia, and Lithuania, and Estonian, Anneli Alika from Estonia, Sandra Stipniece from Latvia, who is the Vice President of Latvian Chamber of Sworn Notaries, and Jānis Krastīņš, who is a member of the Chamber of Sworn Notaries of Latvia. Sajūna Šaltovskiene, a member of Lithuanian Chamber of Sworn Notaries, as Jacques Skiene, also from Lithuanian Chamber of Sworn Notaries. We have a very dense program, that's why we'll attack the first case. We have an hour for 3 cases. These cases are available to you in written. They were in your handouts. And I will shortly present you with the cases, and then I will ask our notaries to comment them. The first case, we'll speak about a person named Dietrich, who holds both Estonian and Austrian nationality. Has been living in Austria since 1995 without interruption. Where he dies in early September 2015. Shortly before his death, he gave up his Estonian nationality so that he is just an Austrian national when he dies. Dietrich leaves movable property as well as real estate in several EU states, including Estonia and Austria. In 2013, in December, he has drafted a holograph will without witnesses in which he chooses Estonian succession law. Under Estonian material law, this will is formally invalid. Estonian colleagues will comment on that, but in Austria that would be formally valid. While it is formally valid according to Austrian civil code, the question remains, which law is applicable to succession upon this death? So I will give the floor to our Estonian colleagues first. Please, the floor is yours.
Meie ülesanne siis on välja selgitada, milline on õigus, mille järgi pärimusesse lahendatakse.
So our task was to state which which country should be applicable. We are not speaking about material law. So we cannot ask this question about applicable law or until we state the applicable law. We first of all have to understand where his last habitual residence lies. And then there might be a question of the citizenship or nationality of the testator. also whether a choice of applicable law is acceptable. These questions should be answered in their subsequent order. First of all, the testator at the moment of writing his will was citizen of two states, Estonian and Austrian. According to Austrian law, he chose Estonian law to be applied to his estate. And he had this choice of law. He could choose whether to apply the law of his last habitual residence or of his citizenship. So this will was drawn before this regulation, European regulation, namely 650, came into force. When this regulation will come into force, the choice of law will be applicable and available.
Kui poleks testamenti olnud, oleks igal juhul Austria õigus kohaldub, aga siin on siis testamendiga valitud Eesti õigus,
At this moment, it is no longer important that the person gave up his Estonian citizenship, nationality. So, nonetheless, he chose Estonian law to be applicable to his estate, and it was possible at that moment. So we have to look at this at the Article 22nd of the regulation, which allows or provides for choice of applicable law. If the testator holds citizenship or nationality of several countries, this will be valid after the regulation will enter into force. In this case, the choice of law is valid, so Estonian law will be applied. In Estonian succession law, it is not important where the estate is located. Dietrich has properties in Austria and in Estonia. When we have stated that the choice of law is valid, so how will we execute this testament, and how will it come into force? Now I will give the floor to Latvians. Yes, handwritten or holograph testament is valid. That is contrary to what's said in Estonia. So in Latvia that would be valid. And one could see this question as to the substance. Now, contrary to Estonia about the applicable law, unfortunately in Latvia at the moment of writing a will, the choice of law is unapplicable. At the moment, it will be possible only after the regulation will come into force. Those are the only differences from Estonia. Very good then. Then I'll give the floor to Lithuanian colleagues, please. Your comment. If a person, instead of Estonia, he would have Lithuanian citizenship, the situation would be the same, but the same as in Latvia, we don't provide for for choice of law, but as we consider Article 83.2 of the regulation, then after the regulation will come into force, this choice will be possible. Namely, Article 83, Paragraph 2 of the regulation. You can see that applying the succession law and the new regulation, the situation will change, as we can see. But now I'll ask the Austrian colleagues, a very, very good case, practical case, practically showing us that this handwritten holograph testament, will, Austrian law provides for possibility of such a will to be valid. And let's have a look on at the 27th article, which provides for such a will as to the substance, as well as a second article from Hague Convention. So we are looking at the matter as to the substance and as to its material validity. So these testaments are valid. So we have to look at the will as to the substance and as to the form. This expression of the last will is possible in all European countries as well as joint wills. So then we can look at another articles from the Austrian legislation, whether the person is capable of drawing such a will, whether this person has done so willingly and in good faith. According to German legislation, the question of statutory possibilities remain, and this possibility of applicable law is valid, but then we have to look at the Article 22nd of the new regulation, which provides for choice of law. And in this case, Estonian succession law is to be applied, and it is valid. This choice of law is valid. Thank you very much. Thank you for addition from Austria. So we can see that this case shows what is provided for by Article number 5, that the parties can mutually agree upon applicable law. So an Estonian notary can handle this succession matter. But if we are speaking about a state that's been located in Austria, then we have to execute lex rei site, meaning that Austrian legislation is being applied to the state located in Austria, but the jurisdiction is in hands of an Estonian notary. So, and now it is possible to ask questions. We will not postpone the questions for the end. So, the message is clear, now, never. Questions about this case can be asked now. Please. Everyone is certain about situations like this. So you have clients coming to you and having similar matters. So you understand what is the case now and what will be valid starting from next year. So maybe Sandra or other panelists or the board members or anyone has some questions. So the first part, the morning session, was dedicated to problems, or how we will overcome our problems. And the regulation will involve many difficulties and problems. And no one wants to think about problems before they occur. But now it is a possibility to solve the problems before they arise. We have a year. The regulation will not be postponed, and it will not change in a year. So, questions?
If there are no questions indeed, and if panelists have nothing to add, then the chairperson of the panel could switch to the second case, outline the situation, and provide what are the comments and so on. Thank you. The second case, depending on the law of member states, can have a different solution or different effect, and this fact will not change as the regulation becomes effective. Colleagues will be able to apply the know-how they have had before, whereas others will have to start applying new provisions. The second case is quite similar. The person in question has a double citizenship, in this case Lithuanian and Austrian nationality, who dies in early September 2015. Before the effective date of the regulation, he had executed a will, and he had selected the Lithuanian law as the law governing his will. However, it turns out this will is ineffective as to its substance in Lithuania. However, it is effective under Austrian law. The last habitual residence of Dietrich had been Austria. I would like to give the floor to the Lithuanian delegation to provide their comments regarding this case. Firstly, we have to talk about the fact that in accordance with the regulation and the transition provisions, the person could have selected the Lithuanian law because they have the member state law. However, due to the lack of will or other incompletenesses, the will is incomplete. So, thus, in accordance with Article 24 of the regulation, the validity of a will is determined, which would be applicable to this will if the person had died on the date of expressing this disposition of property. So it would have been Lithuanian law. However, in accordance with this law, the will is invalid. And in our opinion, if the will is not valid, then general provisions should be applied. In other words, the law of the last habitual residence country should be applied accordingly.
Gut, ich danke recht herzlich. Ich würde gleich Herrn Dr. Schaller suchen, vielleicht in diesem Fall
Thank you.
Stellung zu nehmen. Es gibt hier
I would like to give the floor to the representative from Germany.
eine gewisse Systematik und
Great differences exist in comparison to the first case, and I think it can be very well illustrated by the means of applying the regulation. In essence, this has the substantive, the material effective, the validity, which is of decisive importance in this case. Article 24 of the regulation should be observed. This is the article that we have to follow. And if the person died on the day when the disposition of property was expected, the person, Dietrich, since he had chosen to apply the Lithuanian law, and if he dies on the date he adopted the decision and it is affixed somewhere, if it is entered somewhere, then it would be applicable. However, the Article 24 of the regulation lays down the fact that the person mentioned can choose the law that he or she could have chosen to apply in accordance with Article 22. If in accordance with the substantive law, the one or another legislation can be applied, then this can be viewed generally. This can generally apply to the validity of the will as such. The discussion was about the choice of the succession law that should be applied to the case in question. We assumed that if a person wanted for Lithuanian law to be applied to his will, then in accordance with the regulation, the person in question, in other words, Dietrich, had this opportunity to choose the applicable law. However, the choice of the applicable law in accordance with the Lithuanian law is ineffective. It is invalid. It has no legal force. Thus, the choice of the application of law should not be actually taken into consideration, and one must adopt a decision on the basis of the person's habitual residence, which in this case is Austria. Article 83 of the regulation also doesn't change anything in the stance, because the choice of the applicable law, as I mentioned before, requires to determine clearly the situation. For example, Article 83, paragraph 2 and Article 83, paragraph 3 lays this down. In accordance with both of these paragraphs, there is no choice of law provided. Therefore, Austrian law is the prevailing law that should be applied. Considering international private law, nothing would change, because neither Austrian nor Lithuanian law provides for that, and the international private law provides for that. Thank you. Now, I would like to give the floor to the representatives from Estonia. What would the situation be in this regard? Does the becoming effective of the regulation change anything in this regard?
sureb meil 2015. aasta septembris, siis
Since Dietrich died in early September 2015, the regulation can be applied to all succession matters where the testator has died after the 1st of August 2015. As for the testator, one must keep in mind the following. Whether the validity of the will in accordance with the regulation can be assessed as such using the regulation. I can't find the corresponding article of the regulation. However, the regulation generally lays down that the provisions of the regulation are applicable to previously executed wills only in the case if these wills are compatible with the provisions of the regulation, but I can't find the corresponding article, unfortunately, for the time being.
Seega tuleb ütleb määruse artikkel 83 lõige 4, et kui korraldus surmapuhuks tehti enne 17. augustit 2000.
What we are talking about is Article 83, Paragraph 3. Disposition of property executed between the 17th of August 2015 is admissible and is valid if it complies with the provisions laid down in Chapter 3 of the regulation. One must also keep in mind the fact that the chosen law, which is Lithuanian law, is applied. At the same time, one must verify whether the Lithuanian law can be applied with regard to the substantive effectiveness. Article 23, paragraph 1 sets forth the general applicability. The law must be applied with regard to the material or substantive validity, and this succession procedure as such assesses what was the last habitual residence of the deceased person, and in this case it would the responsible court would be the court of Austria. Thus, the Austrian legal system would be the valid one, and I think that this entire matter of succession, including the material or substantive validity, should be distinguished in accordance with the Lithuanian legislation. Thank you. Now I would like to give the floor to the Lithuanian delegation. Oh, it is the Latvian delegation, the Lithuanian stock. If we assume that Dietrich has double citizenship, both the Lithuanian and Austrian one, then the choice of law would be possible as such only if the will is drafted after the effective date of the regulation. If, in accordance with the circumstances, the conditions of the law, we see that the will is drafted in 2013, then the choice of law would not be possible in accordance with the Latvian law. And as it was mentioned, Article 21 of the regulation was applied in terms of the last habitual residence. We also think that Article 21, paragraph 2 would not be applicable regarding the closest link to Latvia because according to the actual circumstances of the situation, this cannot be inferred. If it can be proven that Dietrich had a closer link with Latvia as opposed to Austria, then we could discuss that. However, according to the conditions of the case, we see that Dietrich had a closer link with Austria. That would be all.
Dankeschön. Ich darf an dieser Stelle wieder
Paldies.
wenn Sie Fragen zu diesem Sachverhalt haben, das Podium steht Ihnen zur
Thank you.
Verfügung. Wir werden versuchen, allfällige Unklarheiten heute, sofern es möglich ist,
Now,
zu
the
beseitigen,
audience is welcome to
sodass
ask
Sie
questions if you have questions or if there's something unclear. Let us clarify that to the extent possible. We are trying to anticipate, to model what kind of difficulties we will encounter within a year and a half. Thank you. I am an attorney from Tallinn. Thank you for the review of these two cases. In our opinion, it is so that we should know well the application principles of the regulation, because many people are drafting or executing wills which will be opened after the effective date of the regulation. Therefore, it isn't correct to claim that we have still a year to go to become acquainted with the regulation. Notaries should know how to apply it. And Dr. Dorsel mentioned before lunch that if we recommend to choose the law applicable to a succession, then one must be aware of the notary's responsibility for a poor recommendation or a poor suggestion given to the client. I don't think that that one should be so afraid in this case, because most probably notaries' mistakes will be buried, so to speak, with the deceased. But if we talk about it seriously, I think that we have to identify the two main cases regarding the application of the law. Firstly, if it isn't doubtlessly clear regarding the habitual residence of the deceased person, if difficulties are anticipated regarding the determination or the establishment of the habitual residence, I think that one should consider the forum shopping should also be considered in terms of the jurisdiction to be applied. I think that in many cases it will be easiest to apply the law of the countries where heirs live. That is one thing. If questions exist regarding the reserved shares, which is applicable to cases in Germany and Austria, then I have to say that in Estonia, it is very difficult to talk about it, because we don't really have such reserved shares with regard to minors. And one can choose the application of Estonian law if he or she wishes to do so. I think it is very important to know the legal norms of the country of question.
So, these are the main questions that I consider valid for this, regarding this case. Already for many, many years, it has been valid question also in Estonia, and clients are not entirely sure about cases like that, and especially in Estonia, it is a valid point and question. Now, do panelists or from anyone from the audience has anything to add? Maybe anyone else from the audience can come up with a question. If you don't have any additional questions at the moment, then we could probably give you questions. For example, we can compare the first and second case. They're kind of similar, but where lies the differences?
Ja teist kaasust nüüd omavahel võrrelda, siis need peamiselt olid valitud need riigid selle mõttega, et juhtida siis tähelepanu, millest
we compare those two cases, the first case with the second case,
me lõpuks siis nagu maandume, et mõlema
then
testament oli tehtud Austrias,
the main difference
kehtis, aga poleks kehtinud
is the question about
testamendi tegija ise valis.
applicable legislation, or the legislation of which country is applicable. The will is drawn in Austria, or had been drawn in Austria, but the will is not valid in Estonia, so the country which the testator chose. So, because Estonian succession law provides for the fact that holograph wills are valid only for 6 months. Afterwards, they cease to exist, if I may say so. That's why the will should be interpreted based on Austrian legislation, because Austrian legislation provides for choice of law. And now, if we analyze this will applying the Austrian law, and I might add also Lithuanian law, then the choice of law would have never, ever been possible and would have to be looked, the succession matters would have to be handled in Austria entirely. So, do you have any questions to case 1 and 2? Have you ever encountered such cases in practice? What would you do in your daily life if a person would come up with you with a similar case or question? Okay, if no other questions, then the third case, I will read out the third case. Okay.
Der Fall mit der bulgarischen Staatsbürgerin.
So the case, we are speaking about Elena, a Bulgarian national.
Ein bisschen wirklich konzentriert zuzuhören. Es ist passiert das.
Please pay attention, because notaries do encounter cases like this on a daily basis, and this case is taken from our daily life, and our task is to outline and to make suggestions that are correct and legal. So we are speaking about a Bulgarian national named Elena, a wealthy one, She is well educated and suffers from a chronic disease of which she is likely to die in a couple of years. Even though she has two minor children and a husband named Svetlan in Bulgaria, with whom she lives in a luxurious villa, she decides to accept a well-paid job with a large corporation in Vienna in November 2013. She rents a spacious penthouse in the first district, and first district is in the center of Vienna, and commutes to and from Bulgaria to her family, which is a rather lengthy voyage, but frequently in the first few months, but less and less frequently later on, as she has an Austrian lover named Hubert in Austria. However, she spends her entire annual holiday in Bulgaria with her family. In August 2014, she drafts a will. A year after she has accepted that job, she drafts a will in Austria that's valid as to form, according to Austrian requirements, in which she chooses Austrian succession law by referring to the regulation that will take effect in a year, and appoints her Austrian lover, Hubert, as a sole heir. The underlying motive for her wish for Austrian succession law to be applied is the fact that, under Bulgarian succession law, she understands that her spouse and her children would be entitled to a reserved share of 5/6 of the entire estate, and only 1/6 would remain for her lover. 1/6 would remain for her lover, but while under Austrian succession law, the Austrian lover would be entitled to half of the estate. So much more than according to Estonian succession law. So Elena dies on the 30th of August 2015. And the question is, the succession law of which country is applicable?
Erbstatut ist diese Abhandlung zu führen, und ich darf, bevor jetzt dann gleich die erste Delegation ihre Ausführungen.
And I will give the floor to the first delegation. I think it's Lithuania. Who has the floor right now? Is the case clear to everyone? In this case, that the applicable law is Bulgarian law. So, and as a result of which the lover, Hubert, will receive only 1/6 of the estate, because according to the regulation, the main question about private international law and applicable private international law and succession law, the question is, which was the last habitual residence of Elena at the moment of her death? It's actually very difficult and impossible to say which was her last habitual residence and whether she had rights to last habitual residence in Austria. The recital 24th calls upon the possibility for change of last habitual residence due to economic reasons, remaining or keeping one's habitual residence in her national country. So, according to the regulation, even if she has spent more time in Austria than in Bulgaria, she could not call Austria her last habitual residence. Based on the Article 4th of the regulation, the entire estate of Elena falls under the jurisdiction of Bulgaria, and according to Article 21, the entire estate will fall under Bulgarian succession law. Anyhow, Austrian succession law is not applicable because Elena, the testator, is not an Austrian national. In addition, it cannot be applied based on 82.3 because the choice of applicable law is not valid in Austria and is not valid in Bulgaria either. However, if Austrian court would decide or rule for the fact that the last habitual residence of Elena was Austria, not Bulgaria, then private international law would have to be applied to entire estate of Elena. If we are speaking about applicable law, then we have to look at Article 21, paragraph 2. Then Austrian court would have to come to a conclusion that taking into account the ties of Elena with Bulgaria and her Bulgarian nationality, her ties with Bulgaria are still much stronger than her ties with her last habitual residence at the moment of her death, namely Austria. So I come back to where I began. As the result of everything that I've said, that according to what we understand, the Bulgarian succession law would have to be applied to her entire state because the heir mentioned in the will, Mr. Hubert, will receive only 1/6 from her entire estate, not everything or even not some thirds or some other parts, as it was mentioned in the will. Thank you so much, and we will ask Austrian colleagues to come up with, sorry, not Austrian, but Estonian colleagues. Yes, thank you. In this case, the main issue lies with the fact of finding out the last habitual residence. According to nationality, it's clear that according to her residence, it is not. Before, we were saying that in Austria nothing will change with coming into force of the regulation, but unfortunately it's different speaking about last habitual residence, of definition of this. The Estonian legislation provides for several such habitual residences, but the regulation speaks about only one last habitual residence, thus excluding from the scope other places of residence, be it economic, tax or job issue related residence or place of life. In regulation, it's been stated that the last habitual residence lies with closer ties or with family, and sometimes it's very difficult to separate those things and to evaluate them. Elena tried to choose her last habitual residence, but unfortunately the regulation didn't provide for such rights to Elena. It's a question of substance in the regulation. Unfortunately, you can choose between your objective place of habitual residence and your nationality. You cannot choose to wish to live somewhere else where you are not living and where your ties are not sufficiently tied. And this regulation provides for one habitual residence, last habitual residence, although regulation doesn't list the criteria to be applied for determining this last habitual residence. So if you look to recitals 21 to 24, we could even look at ACG rulings where ACG has not come up with a ruling of a definition of last habitual residence speaking about successions. But if we speak about payments of substance, there ACG has ruled for the definition of last habitual residence, and there the criterion are very, very clear. I'm sorry, about subsistence, payment towards subsistence, there the rulings are already done by ACG. And now we have to find out where the cluster of interests lie of the person. It can be tax issues, her family, her property, everything, her friends, her social life, in order to gather this information about this last habitual residence. And this information can be obtained from heirs, from relatives. And that's it. And now I'll give the floor to Lithuanian colleagues of mine. So as colleagues from Estonia and Latvia already answered to all the questions and also gave the comments that we wanted to give when looking at this case. I would like to add to Estonian colleagues' remarks that they will have some changes as to regulation coming into force. In Lithuania, the situation will not be the same because the last habitual residence, the determination of it, coincides with parameters or with the definition of the regulation speaking about this last habitual residence. And maybe it might be interesting to find out if Elena, what would be the case if Elena were Lithuanian, not Bulgarian national. Then the situation would be quite similar because according to Lithuanian legislation, she would not be entitled to choose the applicable succession law because she is not an Austrian national. And then I would like to stress that no necessity would be for her to choose Austrian legislation to be applied because the reserved share in Lithuania and in Austria is equal, is the same. So her lover, Hubert, will be entitled to 1/2 of her property of the estate, and the other half will remain to Elena's children and husband. Thank you. Now we can see with this example that there are different laws, different applicable legislations, and the decisive factor is the nationality of a deceased person. In practice, it's rather easy to find out the nationality of a testator. Usually it's not a complicated question, but when the regulation will come into force, next year in August, then we can take into account that the decisive factor will fall with the last habitual residence of the deceased person, where we can see the same from this example, because Elena was spending more time in Vienna. She had her lover there. She had her social life there, and her children and her husband were not there, but there were many reasons why she chose Austria. Of course, she spends her vacation in Bulgaria, but the question would remain, which would be her last habitual resident, and it's the question, and the question is clear, the answer is not clear.
Das Motiv für die letztendlich unwirksame Rechtswahl der Elena
Speaking about her motives to do so, to choose the Austrian succession law, although Elena was not entitled to choose the applicable law, the reasoning of her reasoning was she wanted for her lover to have a bigger reserved share. But then we have to look at the public order, or in French, ordre public. And in this case, we could say that maybe it's a question of ACG to be ruled to form a precedent for the European Union to be able to determine the question about this last habitual residence, or whether public order is observed or not. It's also very interesting from the public international law, from the perspective of public international law. Thank you. I see two very important problems. First of all, the last habitual residence of Elena, and this question should be interpreted autonomously regarding the regulation. And it's very difficult to apply individual laws of individual countries. And now we would have to wait for the definition. What would be the definition of last habitual residence of ACG, of European Court of Justice, the rule when they will rule about last habitual residence. Then speaking about Article 21.2, there are exceptions about defining last habitual residence, whereas then cases from force to on will speak about private international law, and there will not be any exceptions. Another question of problematic question is choice of law, which is ineffective, having no legal consequences. And then here the member states are, the point of the member states is very valid, because when we worked on the draft proposal of the regulation, the testator, the fathers of this regulation didn't want the testator to give this option of choice of last habitual residence. And what should I do as a notary if a person comes to me, even this Elena or so, What can I tell her? Either she could change her last habitual residence and go to Mongolia or Thailand. There would be no problems and there would be no forced heirs. And she would not have to mind any reserved shares and think about that. But that would be contrary to ordre public or public order, because forced heirs is a backbone of succession, setting for certain guarantees for for this order, for law as such. Now, Estonia, please. Thank you. I wanted to draw your attention to an additional fact. We are speaking about a testator having choice of applicable law as well as choice of one's land, the country of which the law will be applied. But how could that stem from the will? 21.1, first sentence, determines Article 22nd, paragraph 1 says that this ability of applicable law is being expressed in a will unless otherwise provided for in this regulation. The law applicable to the succession as a whole shall be the law of the state in which the deceased has his habitual residence at the time of death, unless determined otherwise. So it's kind of vague in what form this expression of will should be expressed, or this disposition of property. So in Estonia it's not entirely clear, and there are many questions that remained unanswered about this disposition of property of the deceased person. So thank you very much, everyone. It has been provided for that the choice of law should be expressed explicitly. And in the morning session, we already heard several practical examples of how one can prepare oneself to undoubtedly point out this choice of law. And I think that in this third case, as Elena doesn't have Austrian nationality, she cannot ask for application of Austrian succession law to be applied to her succession. And according to the provisions of the regulation, although she spends most of her time in Vienna, she is not entitled to apply Austrian law to her succession, because Austria is not being considered the last habitual residence of hers. Please, let me ask you, if you can come up with a solution, or you would like to ask or add anything, please do so now. You can ask us now. You can probably twist this case and come up with a bit differed variant.
Dann darf ich jetzt ganz keck daraus schließen, dass wir Sie hier umfassendst
If not, then I will conclude that we have
Fragen ausgeräumt sind und dass Sie
that we have exhaustively looked upon this matter, this case, and you have been prepared to apply the succession regulation, even in cases like this with Elena, and you are ready for coffee.